Okay, and we are live. Hi, everybody. It's Uncle Grumpy, and welcome to Grumpy Tonight. Hey, I got to that other screen before it made background noise. All right, let's see. So I got to turn this down. Too many devices. I'm never ready. All right, folks, please share this if you don't mind. As you can see, we are here with Dr. Lawrence Pasternack. How you doing, Lawrence?
Oh, I'm doing okay. Busy day,
Okay.
lots of meetings.
Well, normally you say, "Oh, I'm tired," so that's different. So that's
Yeah,
much
I
better, I guess.
purposefully said something different this time.
What's that?
Excuse me. I purposefully said something different this time because you
Oh, I
normally
see.
say, oh, you always say
All
you're
right.
tired.
Yeah, you're being a contrarian. All right, let me see if I can
Yes.
share this to our page.
Hello, Mo.
Yeah, I want you to talk to anybody who joins in for a second while I try and share this.
Hi, everyone. We're going to basically go over ORCA's full access petition language. That's going to be our focus tonight. There it is. I'm just setting it up on my computer.
I love your background. Let's talk a little about your background while I'm doing this. Did you want an audience? Is that what you call an audience?
Well, something that perhaps very few people have noticed, it crossed my mind one day and I did a little research on it. The white part of our eyes is called the sclera, sclera. And something that's quite surprising is that almost no animals at all have white scleras, with the exception of humans, some dogs, some horses. So basically, animals that we've domesticated to interact with. Well, wolves don't have white sclera, dogs do. So I think there's something about the eye-to-eye communication that there's a selective advantage to having a white sclera because you're more able to recognize than the colored iris against the sclera background. So it sort of helps us bond with a creature as well when their eyes are more like ours.
Okay. So I just went back and changed the setting again. It was set back to only friends. So hopefully anybody who may have had trouble seeing it when it first started can see it now. And since we haven't really gotten started yet, you haven't missed much.
Yep. I'm going to put in the back in the comments orcaok.com, I believe what it is. Oops. ORCA.ok.com.
Okay.
Let me just double check. ORCA OK.com. And the rec petition, I'm pretty sure is accessible through the following link.
Okay,
I think that's right.
I've shared it to a few places. If you guys don't mind, please share. All right, so let's get started, Lawrence. Last time, well, maybe it was last time, but recently we talked about the full access or the medical petition. I'm sorry, and tonight we're going to talk about the full access petition that ORCA's released. Now, Lawrence, I've got this set to screen share. I'm betting some of these people want to get right in it, so let's pull it up if you're ready, and let's start talking about it and see what's in here.
Sure. Just as a quick moment of context, just to fill people in if they're not familiar with the details, a group of activists identified as ORCA, Oklahomans for Responsible Cannabis Action, are hoping to have initiative petitions on a 2022 ballot. Two different petitions, a medical constitutional petition that basically takes our existing program, the principles of 788, does a few fixes with regards to the regulatory agency, beefs up some of our protections having to do with employment issues and so on, and puts it into the Constitution. So that's one petition. We've talked about that in the last week or so. And then the goal was to have what was characterized as a quote unquote plug-in for the medical petition that would further authorize full access, and they're independent of one another. And the full access was written so that it could, if it passes, either pass and work with the medical constitutional, or in theory, still work with our existing program. So that's kind of the logic behind it. Two separate petitions, people could decide whether they want one or both. And the ideal basically is that you have one, the medical, that's constitutional, that secures all our rights in the Constitution, and then the full access one, in theory, could either be constitutional or statutory. So that's the background. And for my convenience, I downloaded this into Word. So let me just open up the Word here and do a screen share. So just bear with me for 1 second as I move something around.
Okay, let's start with something you just said, Lawrence. You said it could be constitutional or statutory.
Yep.
Why would we, I'm going to ask right off the bat, why would we do full access? What would the pros or cons be of doing full access just statutory? Why would we not? Isn't the goal here to take the power away from them anyway? And the only real way to do that is put it in the Constitution. Before we even get into, just to argue the merits of it.
So to get it, so to get it into the Constitution is heavier lifting. To get it into the Constitution, you need more signatures. But as well as that, I think it was Rachel Bussett who said that whatever goes in the Constitution must be as good as humanly possible. So the margin for error is less when something goes into the Constitution, because it basically takes another initiative petition to fix it. But then the other issue is this, that as originally conceived, the full access petition was nothing more than just a one-page plugin, right? And so as such, there may not be a need to put into the Constitution. It basically just says patient card is optional. You either can have a patient card and pay less in tax, or not have a patient card and pay more in tax. And if that's all that there is to it, then maybe we don't need to put it into the Constitution. But there's a lot of moving parts. And so I think it's just going to be a debate, right? A public discussion that hopefully we're helping to spark through events like this, where people can deliberate as to which route is the better route.
Yeah, I find that to be an interesting one. I can't wait to see how everybody else feels about that. I've said this from the beginning. I think it needs to be in the Constitution, but my personal goal has been to try and get the home grow in the Constitution, so every Oklahoman can grow cannabis, and whatever form that has to take to make that happen. And I see this as the easiest avenue, but it would have to go into the Constitution. And as to the numbers, I say there's so many card holders that I understand the cost would be greater, but I think getting the signatures should still be an easy hurdle to overcome when there's more card holders than there are. And I know not everybody would be for it. I understand that, but there's already more card holders than you need signatures. And we all know that a great number of people that have been calling for this can't and won't, or for whatever reason, get a card. So, I think getting the signatures will be pretty easy. So I don't see that.
Yeah, and then when it comes to
go ahead.
And then when it comes to the ballot, some people will be willing to accept it as statutory that may not be willing to accept it as constitutional. So I think it's just a matter of, this is not a decision that has been resolved yet. And thus the way in which ORCA drafted it, they drafted in such a way that in theory it could just be shunted over into a statutory petition without much in the way of any real changes. So it's right now written as constitutional, but it won't take much to revise it for statutory.
All right.
And, we're a few weeks out before we actually file it for signatures.
So before even opening the
Get
page,
ready to go.
Argument right there. But yeah, go ahead. And I've got it set for screen share. You go ahead.
All right. So I put the link up to access the petition via the ORCA website. I downloaded it just a few minutes ago onto my computer just because it's easier for me to scroll through this way. It's a live document, so things are kind of going to be changing periodically through individuals' comments and just simply typos being caught and so on. But the sort of the bulk of it is, I think it's 7.5 pages at the moment. And the idea basically, again, is that it's meant to be a plug-in to the medical petition, which we previously discussed. Somebody says, Rita McRae says, won't this put grow houses out of business if everyone started growing their own cannabis? Let me just say this, that everybody right now is legally allowed to grow cannabis with a patient card. So everybody who's legally allowed to buy in a dispensary is legally allowed to grow right now. And my guess is that probably under 10% of the people with patient cards exercise their grow rights. So if we had a full access program, again, my conjecture is probably less than 10% of the people who are legally allowed to purchase cannabis would be growing it at home. Once again, right now, just about everybody.
Listen, I want to point out that we've had Mark Woodward on here, the LBNDD, and we've talked about all the illegal cannabis businesses, and that seems to be the nightmare for the legislator and for everybody else is the illegal cannabis businesses. We're not hearing any problems with the home grow. We're not hearing that it's taking over the market, that it's flooding the market. We're hearing that the illegal businesses are flooding the illegal market, but we're not hearing that there's a problem coming from the home grow. So as Lawrence has given with the numbers, there's absolutely no reason not to give everybody the right to grow. Not that many people are going to be able to utilize that. It's not not nearly as easy as everybody thinks.
Yeah, and from my position, this is an innate natural right we should have to grow our own, right? This is a plant, and we should be able to grow it and process it and consume it and do whatever we want with a naturally occurring plant. So I think that the idea of home grow is sort of speaks to sort of part of the deep meaning of cannabis as a kind of personal autonomy issue too. But let's start going through the act, which for now is called the Oklahoma Marijuana Liberty and Regulation Act. It begins section 1. I'm not going to read everything all the way through. I'm going to sort of just read some of the key parts and to summarize some of the others. But it starts out by saying, nothing in this article may be construed to limit or abrogate any privilege, right, immunity, or defense of medical marijuana patient licensees, caregiver licensees, or medical marijuana business licensees. So the idea is that, once again, this is just a plug-in or an add-on that's not supposed to in any way impair the medical program. It's ideally, ultimately, it's basically exactly what we have, except it says you don't need a card. If you have a card, you pay less in taxes. If you don't have a card, you pay more in taxes. That's sort of basically the idea here. Same license structure, same rules. It's just anybody can go into a dispensary and purchase. Anyone over the age of 21 could purchase without a card. So the language throughout this entire petition is basically a duplicate of the language in the medical petition, just with minor revisions. Like, for instance, in the medical one, it says persons with patient licensees or caregiver licensees shall be allowed to so and so. So here it says it shall be lawful for all persons 21 or older to grow, purchase, transport, receive, and we added in here, share and gift, prepare and consume marijuana. The quantities listed here are basically what we have with 788, just adding in suppositories. And the amounts are cumulative. So just as a little point of clarification, one thing that got changed in statute this year was possess any quantity of cannabis that they grow at home. So if you grow 7 pounds of marijuana out of your legal plants at home, you'll be legally allowed to possess that. And so here, likewise, it says you're allowed to grow up to 12 plants. So rather than saying 6 mature, 6 immature, it says 12 plants and the marijuana harvested therefrom, which is basically what we have.
And hold on just a second right there. I kind of like to call this my disclaimer that I feel is important to get in here when we talk about that. I highly recommend that you keep a little piece of your stock so that if you ever find yourself in any trouble, you'll be able to prove that that's what you grew. So keep the bottom couple inches and maybe a little part of the root ball, and you're good.
So if you're so if you're a home grower and you harvest 7 pounds, then it's a good idea to have some evidence that actually you grew that at home.
Right.
Legalizing
that's how it's done in other states that allow you to do it like that, like this. And we were able to get this done without that particular part, but to cover yourselves, just to keep yourself out of trouble, keep that. And because we never know when someone's going to overreach a little bit. Go ahead, Lawrence.
So some pretty straightforward stuff, legalizing paraphernalia, and just to make it all the more clear that everything that's legal here is legal. Possession of marijuana within limits indicated shall not constitute either a criminal or civil infraction, shall not be subject to any penalty, fine, sanction, or punishment. All right. General protection language. This is a duplication of what's in the medical petition. Basically, it's saying that anything that you're doing here within the boundaries of this article, there's no arrests, there's no penalties, there's no prosecution, you're not going to be denied any public benefits, not denied healthcare, not denied housing, and so on and so forth, not denied any public assistance programs. And also, again, from the medical.
Lawrence, let me ask. So what you're saying is it gives you all the same rights as cardholders have now, and in avoiding arrest plus some. So everything that's in the medical petition would then be anyone over 21.
Yeah, everything, all the rights that are in the medical petition will be extended to all persons 21 and older with respect to cannabis in this one. So, nothing about cannabis use for anybody shall be the basis for any kind of denial of a benefit or punitive measure or anything along those lines.
All right, one of the first questions that's going to be asked is then what happens to the medical program? How's the medical program still function? I'm just asking.
Yeah,
there's
a lot to say about that, but the basic idea is that nobody should ever have to go to jail. Nobody should ever be criminally punished for cannabis. Right now, thousands of people every year in Oklahoma continue to face criminal charges from simple possession. Over 20,000 people have been criminally charged. This would stop that. And so what happens to the medical program? It's going to be an issue of tax. If you want to have a medical card, you get your physician recommendation, you get your card for 2 years, and you will, if this passes, pay no tax, no excise tax.
So
the 7% excise tax.
So this wouldn't make any changes to the medical petition should it change for the card holders.
It makes no changes to the medical program with the exception of getting rid of the excise tax.
Okay, so that then benefits the card holders.
Yes.
Okay, go ahead.
And Jackie Wolfington says you still need a commercial license for selling. That's correct, right? Any transfer of cannabis with consideration, any sale of cannabis is a commercial venture and you would need a license for it. You can gift cannabis, that is transfer without consideration, but with this petition, but there is no selling it without a license. So we'll get to the tax issue because there's more to say about it. But also it says here that in no way whatsoever could they use the presence of a THC metabolite as the basis for denying you anything, as the basis for treating you as impaired. So if any kind of entity, an employer or whatever, wants to test you for a metabolite, they can't use this as the basis for denying you anything. All right. Privacy rights. So it's sort of just as general catch-all privacy. The language for privacy in the medical program is a little stronger because we could then appeal to HIPAA in the medical side of it. But here, basically for full access, it says the handling of any record maintained by the agency authorized to regulate or businesses shall comply with all applicable state and federal privacy laws. So imagine the following. If this passes and it's legal for anybody at the age of 21 or older to purchase cannabis, all you need to do is walk into a dispensary, show a driver's license or passport or whatever, proving that you're 21 or older. That's all you need to do. Proof that you're 21 or older. They don't need a license or anything beyond that. You prove you're 21 and older, and you can purchase cannabis. All right. It's no longer something purchased under a license. It's simply just proof of age. Like if you go into a liquor store and you buy wine or beer or whatever. Right.
And so this doesn't also wouldn't really change the businesses. They just charge a different tax at the register.
Yeah, so no difference at all with regards to businesses, no separate licensing, no separate rules. Basically, if this passes, a dispensary can simply just sell to people whether or not they have a card. A grower does exactly what the grower does. The processor does exactly what the processor does. No changes at all in the industry. Except that if you go into a dispensary, you don't have to have a patient card in order to buy it. You just have to have proof that you're 21 or older. And there'll be a difference in tax, which we'll get to. Employment rights. So one of the things that both the medical petition and this petition does is it beefs up our protections with regards to employment. And so no employer, this includes safety sensitive. No employer, safety sensitive or not, may refuse to hire, discipline, discharge, or otherwise penalize an applicant or employee solely on the basis of conduct permitted by this article. It says the same thing in the medical petition. And so they could still test you for active THC. So an employer could still say, we think maybe you were impaired at work, there was this accident, and they could test you for active THC. They could take a blood test, for instance, to see if you are actually impaired. They can use other tests, kinetic tests, cognitive evaluations, but they can't use metabolites. And like I said, this beefs up your protections as an individual who's employed. The medical has the same language as this, protecting you as well. Healthcare rights, because even if it's not a medical user, you should still have medical protections, because pain management doctors will terminate patients who have THC in their system. So whether or not you have that THC from a medical card or you have that THC from an adult use program, you need to protect the access to medicine for everybody. So it says, for the purposes of medical care, cannabis cannot be construed as an illicit substance. No medical practitioner shall deny or alter treatment on the basis of you're using cannabis. And an important sort of legal framing here is that we're defining the standard of care for doctors in such a way that they are able to prescribe opioids, benzodiazepines, or anything to people who use marijuana without having to modify it. Oh, I just noticed here, to medical marijuana patient licensees. There's a little fix we got to put in. When this language got transferred over, that should just say, do persons engaged in activity authorized by this article? So actually this says to persons. Jed's probably watching. So right there, we just changed the word to persons.
Lawrence, I'm not seeing any comments, so I'm hoping you are.
Yeah, so I am.
It's been showing me who's been watching when people join.
So yeah, I'll respond. So Steve Noon says federal laws for commercial drivers still apply, though. That's right, because if there are federal laws, there are federal laws, and those will still hold. Paul Bellamore says, how will impairment be determined in a workplace environment? Well, having a metabolite doesn't show impairment. To show impairment, they would either have to show active THC or they have to show that you're impaired through cognitive testing.
But hold on, Lawrence. But in reality, this doesn't say how they would have to test. It just says how they can't test.
Right. What it says is this, that they can't use the presence of a THC metabolite as the basis for determining impairment. They can't deny you anything on the basis of a metabolite. So they could do cognitive tests if they chose. They're free to do that. And they could do active THC tests. They're free to do that. But they can't use a metabolite test as the basis for determining impairment.
All right, I got
All
it.
right.
I can see the comments now. I don't
Yeah.
have all the normal screens. I'm in a different part of the house tonight, so I'm one screen short. Actually, two. I have one phone down too, so I'm having to learn new ways to keep up here.
Yeah.
All right, go ahead.
So parental rights says the same thing in the medical petition. Nobody can be denied parental rights, custody, visitation on the basis of using cannabis. Licensure rights, and this concerns various types of licenses, driver's licenses, and so on, that nobody can be denied a license on the basis of using cannabis. Again, it reiterates the stuff concerning THC metabolites can't be the basis for determining impairment. It doesn't mean that you can't be tested for driving while impaired, but they can't use metabolites as the basis for testing that. They would have to actively determine your impairment through roadside testing and other things.
So let me ask Lawrence a side note here. This would kind of encourage something that you've been pushing for from the beginning, which is cognitive testing, which could be as little as an app on an iPad, right? So maybe
Yes.
something like this, rather than them trying to figure out a different way to test your level of something, maybe they'll actually just test and see if you're impaired.
Yeah, so Mary Jane May asks, what is an active THC test? So Mary Jane, let's say somebody were to consume cannabis. They were to, let's say, smoke a joint. If you were to smoke a joint, the THC gets metabolized by your liver, by other systems, and gets broken down into other chemicals. And so those other chemicals aren't necessarily impairing. You could have metabolites, byproducts in your body for weeks or months after you use cannabis. So the active THC test is only saying the THC molecule itself, that's only going to be in your system for 2 to 4 hours after you consume cannabis. So that they can test for. If they find the active THC molecule, then that gives them some information that's relevant to whether or not you're impaired. It doesn't prove impairment, but it gives you some information. The presence of a metabolite, which is a byproduct, which will be in your system for weeks and months, gives them no information. Like you could smoke a joint today and have, as Paul's mentioning, 50 nanograms per milliliter of a THC metabolite in your urine 2 months later. And so right now, our laws are such that they're testing metabolites, and they shouldn't. Our current law is that it's illegal for a person to drive if they have any metabolites in their system. So if you use cannabis, then you're not legally allowed to drive for months until those metabolites are gone. And that obviously has to change. So we're basically getting rid of the use of metabolites as the basis for any determinations of impairment and so on.
Yeah,
Okay.
the ability for any legislators to get that changed at the Capitol has been not well met at all.
Yeah. Back, I think it was in summer 2019 or summer 2019, I think it was. I worked with Representative Fettgetter, and we wrote language to change it, but we couldn't get the Department of Public Safety to agree to that language. So I was working with Normal, and we were getting some really good language together, but we couldn't get any headway at all, and it just all got stalled. And so Fettgetter did his pilot study with, what was it, Hound Labs instead. Deborah Davis says, perhaps like drug panels that test and tell you what an approximate amount. So Deborah, that's right. The typical drug panels that you see, like if you do a urine test, they're not testing for THC. They're testing for a byproduct of THC, a metabolite. And that metabolite doesn't at all correlate with impairment. It's really bad science that they're using when they test people. That needs to be fixed. So Second Amendment rights. So it makes really clear, just like the medical petition and just like we have now in law, that if you use cannabis, in no way whatsoever does it interfere with your right to bear arms. Federal law is different. We can't stop federal law, but at the state level, we would be fully protected to possess and use firearms, regardless of our cannabis use. One of the really important things I think that both the medical petition and this one does is it extends our protections, because right now lots of people are in jail for cannabis because they used cannabis and while they were under parole or probation. So the parole officer, or while under probation, they're tested for THC, and a positive test will land them back in jail, and we want to stop that. So we're putting into the law here, same thing with the medical, that they can't revoke bail, parole, or probation for your use of cannabis. No punishments, no additional punishments related to use of cannabis. There's nothing that indicates, and this is repeated again, we kind of had it earlier, but it's meant also with regards to your rights for search and seizure and so forth, any kind of police interactions, that anything that you do related to cannabis is not a reasonable articulable suspicion of any civil infraction or criminal act, so they can't use it as the basis for search or detention. No conduct permitted this article shall constitute the basis for detention, search, arrest.
Hold on.
And except when law enforcement.
So Lawrence, hold on. So specifically, I'm sorry to interrupt. I know you hate that, but I want to bring this up. This all addresses that recent court decision, doesn't it?
Yeah, that's right. So that's right. So an appellate court here in Oklahoma about 3 weeks ago issued a ruling where the lower court threw out the search because the basis for the search was the officer seeing marijuana. And so with marijuana legalized in our state, it can't be the basis for a search anymore. That's what the lower court said. The higher court said, no.
Wasn't it a small amount of marijuana too? I know it led to further charges, and that's the problem, but wasn't it just a small amount of marijuana? He had a half a joint
like
or something. Yeah. Okay. Go ahead.
So, right. So what this will do is it'll basically say that the presence of marijuana, the smell of marijuana, anything related to marijuana that falls within what's been legalized, according to this article, cannot be used by a police officer to detain you, to arrest you, or to search your vehicle, to search your person, or to search your premises. All right.
That's how it should be. You see here, Steve is asking about the McGirt decision. You see that one?
So with regards, so my understanding is this: the actual McGirt decision was narrow with respect to simply that if you are a native person on McGirt land, then your criminal proceedings will take place through the tribal criminal system, not the state criminal system. That's really the determination for McGirt. What further implications McGirt hasn't been resolved yet. So imagine this: let's say you're on McGirt land and you're not a native and you're pulled over. This article should still protect you.
I'm not sure
if you are a native.
Hold on, I'm not sure if you heard, because this may change. But recently, I guess the last couple of days, the governor had to file a lawsuit against one of the tribes. I guess they want the oil. They want to control the mineral rights as well. They're taking it beyond. A week earlier, I'd heard I'd heard Mike Hunter say that, as that it was fairly limited, but they're trying to extend it already to count mineral rights. So I wonder where all this is going to land.
Yeah, it's just an unknown. So, who knows what the court system's going to do with regards to the scope of powers the tribal authorities have in McGirt land. Hard to say, right? We don't know. But this is all basically written in relationship to the state of Oklahoma and what power it has in McGirt. The courts are going to have to figure that out. But my guess is that if you're not a native and you're not interacting with native law enforcement, this would hold. And if you are a native and you're interacting with a typical state trooper, this would hold. So I think it might just be that if you're a native interacting with native law enforcement, then federal law and native law might supersede this. But I don't know. All these things are going to have to be figured out in court.
Let's remind everybody it's Dr. Lawrence Pasternack, also not attorney Lawrence Pasternack. I don't want him to be hung for his legal opinions. They're just opinions that I drag out of him, but he does do research before giving one. So it's an educated opinion for sure. Go ahead.
Yeah, and so these are my conjectures given my understanding of things, and I don't think even an attorney right now would be able to tell you what ultimately is going to happen with regards to McGirt. It's unknown territory, so to speak. All right, home grow and local protections. We want to be clear that people who grow at home aren't subject to any additional licensing or fees. A municipal or county government can't impose any further regulations upon a home grow. They can't, municipal county governing bodies can't impose or restrict your personal use of cannabis, you're transporting cannabis in your vehicle through their territory, and so on and so forth. And there may be ordinances like, for instance, it has to be kept behind a fence, or might have to be a locked gate or something like that. But sort of a general legal catch-all term is they can't be unduly burdensome. So what does that mean? So let's say that you're growing 6 plants, and let's say that you're going to end up getting a pound of marijuana out of it. Well, that pound of marijuana as a home grow might be in a sense worth $500. They can't expect you to spend thousands of dollars on security measures for the sake of something that is only worth $500. So the unduly burdensome test will basically have to do with the relative significance and costs and, I guess, impact of what you're doing. They can say you have to buy a $25 lock at Lowe's, but they can't require you to spend thousands of dollars on a security system. All right. No further regulatory agency or business licensing required. And this is an important one, I think, for business folks, because if you go back to 806 and 807, the problem with it is that it just left an unknown what will happen to businesses because it would create separate licensing. This says no separate licensing.
Hold on. I'm sorry, Lawrence. Sorry to interrupt. Before we go farther, I want to address his concern. Steve says, I just don't want the natives caught in a nasty loophole if it's flexible now. This petition, what he's laying out, doesn't do anything to that, doesn't change that situation. I mean, that the McGirt decision is what's causing everything to be up for grabs right now, not whether or not this passes. Go ahead, Lawrence.
Yeah, so whatever uncertainty there is with McGirt for the medical marijuana program that we have now, it's the same as if this passes, right? This won't create any additional uncertainty. The question is, under federal law and under tribal law, is marijuana permitted? That's the same problem with 788 and with a medical petition and with a full access petition, right? And there's nothing we could do as an initiative process to address that, because the initiative process doesn't affect tribal law, right? There's just nothing that can be done. What we can do, however, is write all this stuff for non-McGirt land, and hopefully, as the courts figure things out, it will apply just as well to McGirt land. All right. So what Section 12 does is it basically says that there won't be 2 separate agencies for full access and for medical. There will not be separate licenses for businesses. There won't be separate costs or anything like that. If this passes, the dispensary that's selling medical marijuana could just start selling full access. If this passes, the grow that's growing medical marijuana could start growing for the dispensary that sells full access. It won't change anything in the business world directly, right? It'll mean more customers, but it won't in itself introduce any further regulatory hurdles. Like, look what it says here. There shall be no further licenses, fees, or registrations required by a state agency, county, or municipal government in order for a medical marijuana business licensee to engage in business activities of the same business type, business license type and at the same location for conduct related to this article. And then we flip it so that it applies in both directions. Nor shall there be additional licenses, fees, or registrations required by a state agency, county, or municipal government in order for business licensees engaged in activities related to this article to engage in business activities of the same business license type and at the same location for conduct specific to medical marijuana. So that's very wordy, but basically what that says is that every business can just conduct itself without having to consider whether or not anything being bought is being bought with or without a patient card. Got it?
That explains it.
All right.
Are we about ready to move on to
So,
taxes?
yeah,
I see it popping up on the
taxes.
screen there. I'm looking forward to this part.
Yeah. So I know this is something that a lot of people are worried about, and I share the concerns. I think that my views on taxes might be different than what this says. I think Chris's are, but right now, and I think this is the kind of thing that we need public input on, because it certainly, any of this stuff could change. Somebody has a better idea, please voice it. The excise tax rate for marijuana products purchased by persons without a valid Oklahoma medical marijuana patient license or Oklahoma caregiver license shall be 15%. So basically, if you don't have a patient card, you're going to pay a 15% excise tax. And the legislature could lower that. The legislature could raise it, but no way will they ever be able to raise it above 20. But the legislature is empowered to lower it. And that's just for people who don't have patient cards.
Okay.
Personally,
hold on. Well, go ahead.
oh,
Go ahead. If you want to respond.
no, you go ahead, Chris.
On it. Well, look, you've read it. If you want to give us your personal feelings on it, go ahead, and then I will.
My thought was turn the medical tax to 0 and then have the 7% tax for full access. There are 3 states, Illinois, Michigan, Massachusetts, and the third one is eluding me. There are 3 states that have a 10% excise tax rate for full access. And we have the highest medical tax rate in the nation at 7%. So we need to lower that medical tax. And I don't, personally, I think that we don't need to go as high as 15 or 20 for full access. What that'll mean, though, is that if you, let me just finish this and I'll pass it over to you, Chris. If you spend $500 a month if you spend $500 a year on cannabis, just get a patient card. Save you money in the long run. If you spend $500 a year more on cannabis, just get a patient card. If you spend, if you spend very little on cannabis, then the tax rate is not as important. But go ahead, Chris.
Well, I think that as we know, and as we talked about a couple of shows ago, the federal government's going to do something soon. And there's a possibility that when they do something, or a likelihood that there'll be a tax involved in that as well. Now, it may be an excise tax or something, or the wholesale tax like we talked about in the current ideas that are in Washington of like 25%, which, we assume will just replace the 280E. But I think we need to keep it like you at 7%, because when the federal government changes and when the borders open, if we are that much lower than everybody else around us, the amount of interstate commerce, legal interstate commerce that we will do will be great, and it will outweigh that an extra 5 or even 7 and another 7%. In the long run, I really believe it will. Maybe not for the first couple of years, but after the states around us, even if it's 5 years from now, long term, it will help us if we keep the number lower. And this part about raising it, they could raise it to 20. We might as well make it 20, because if we are past something that the legislator's not if they were so happy about it that they wouldn't raise the taxes given an option, that they'd run it themselves. So they're not gonna like full access coming. And if given the option, they'll if we pass it, they'll justify it to their constituents who don't like it by saying, well, look, we're raising the taxes as high as we can. And so it won't be 15%. It will be 20. So we think it should be 7.
Bear in mind,
It could be 20.
bear in mind the legislature, there has to be a 75% supermajority for the legislature to raise taxes.
And while that may sound like a large majority, what is it, about 85, 86% Republican, or maybe even more on both the Senate and the House. So it's one party rule here. And I've watched as numerous bills have passed with maybe one no vote, somebody who's voting no on stuff all day. So
yeah,
getting a 100% on this, or all but a couple of people, all but one party, if it's the Democrats, it won't matter. It passed without any trouble.
Yeah.
And again, the way they're running legislation through, in my opinion, with this one party rule, this would be an easy thing to get done.
So, two other ideas that I had for taxation here was, what if we had the taxation set up that it balanced off against the federal tax? So whatever the federal tax is, we'd say whatever amount we're setting up as tax and whatever the federal taxes are, the combined amount can't be more than a certain amount. So we basically are trying to protect people from federal taxation. That's an option. Another option is, instead of an excise tax, have a gross production tax. Because once cannabis becomes federally legal and we start selling it across state lines, then it doesn't make as much sense to have it as a retail tax. Because if a grower here grows cannabis and then sells it to a processor in Kansas, then why don't we have the taxation at that level? And why should we have any tax? Well, part of the reason why is because, growing cannabis is very resource heavy on water, heavy on electricity, and so on. And so there's a burden to local farmers, there's a burden to our infrastructure and so on, that creates a rationale for some taxation. But what I could say is this, that I think that the taxation issues, could be a hot button issue for people. Please send comments. I'll put down the website address again, ORCA's website, orcaok.com. Please send in your comments about this issue or any other issue as we move along. If you have other ideas, if you feel strongly about a certain point in tax, please input.
I really look forward to seeing everybody's opinion on that one. Again, I think we need to keep it below 10 for sure. Below 10 for sure. So go ahead. We're finish out the taxes. Go ahead.
Okay. So basically, standard stuff, that this tax will pay for the operational costs of the agency. And the next bit is how the medical tax drops. We don't want to all of a sudden take the medical tax from 7 to 0, because as one program phases in its taxes and the other program needs to slowly phase out. So basically, over a 1-year period, the taxes for the medical side go from 7 to 5, then from 5 to 3, then from 3 to 0. So if you have a patient card, by the end of that first year, you will no longer have an excise tax to pay. There'll still be regular sales tax, but no longer the 7% excise tax on marijuana for patient cards. And so what will the total revenue look like if we had full access? I think that just about anybody who's a regular user of cannabis will want to keep their patient card, because that's a big tax savings. And so, we have almost 400,000 cardholders. About anybody who's making active use of that card, anybody who's spending more than $40 a month on cannabis, is, at least as a matter of just math, going to want to keep their card. And so it'll be people who almost never use cannabis and visitors who will be the ones that will be paying that excise tax. That's at least one way to model it. And how much tax will that be? Until Texas legalizes and Kansas legalizes and so forth, we're potentially talking about hundreds of millions of dollars in excise taxes, and $200 to $300 million, let's say.
And again, as I said, I understand what you're saying about a different tax structure for businesses, and you're right about that. But still, if we have a lower sales tax at the counter, and they can come here from Texas, and we have lower prices on medicine as well, they might just come here. I know people that drive to Texas for those no no tax days and things, those school days and things like that. So that people will take advantage of that. Again, there's a lot of reason to have a lower tax. It will draw people in.
Yeah, another thing that even could go in here is, let's say we were to have a section that said, should cannabis be federally legalized, then the tax rate here in Oklahoma shall be no higher than the tax rate in any of our contiguous states. So that way that whatever the rate is in Texas and Arkansas and so on, we won't be any higher than that. That's actually a nice add-on, that we're going to drop our taxes to whatever the lowest rate is in the region. That's a good idea.
That's an
Hey,
idea.
Jed, if you're listening.
I look forward to hearing what everybody thinks about taxes.
Yeah,
for sure.
So let's see, what else is here? Basically, no additional taxes from counties or municipalities. And the money goes mostly to the general fund, like it does now, earmarked for common education, just like it does in 788. And what this 3% here is, which we'll get to in just a second, is there's going to be a retroactivity part of it that basically says anybody with a criminal record related to cannabis can get it expunged. And rather than they're having to come up with $1,000 or whatever the legal fees, this could pay for it. So where are the tax dollars going to go? In addition to paying for the regulatory agency, they'll go, in part at least, to paying for whatever costs are related to undo anybody's criminal history related to cannabis.
Provided
and whatever's left.
Hold on. Provided that's something that's legal that would be made legal by this article.
That's right. You know, a 25-pound trafficking charge is different than a simple possession charge.
Right. It's not going to help get the cartel out. I don't want people thinking that. It's going to help the Oklahoma people that can't afford to get their record cleaned up.
Yep.
So, and that's what it needs to help.
Yeah. And so next section is expungement. And basically what this says is, and we had a couple attorneys give us a lot of input on this. What this basically says is that if you have any criminal record related to cannabis for activities that would be legal under this article, then you can get that criminal record expunged. And the 3% up here could pay the legal fees related to it, the lawyer's fees and whatever filing fees there are. And it also doesn't stop any other option. So for some other reason, if you have a better option, if there's something that you found in 780 or whatever that helps you more, of course you could use that. That's what this number 5 does. It also, here, a couple other things. With that expungement, it restores your Second Amendment rights and your voting rights. So once you get your criminal record expunged through this, you get automatic restoration of your Second Amendment rights and automatic restoration of your voting rights. So if you're lacking in either of those, this would restore them.
As far as the gun rights, getting those back, it would be a shortcut to that because currently there's 2 processes to go through to get an expungement. There's getting the criminal charges expunged or convictions expunged, and then there's getting your gun rights back. That requires the governor's pardon, which is the more expensive part.
Yep.
Just pointing out.
Okay. Relations to federal law. Part of what it says is if federal law legalized it, then whatever we have in our law will be no more restrictive than what federal law allows. So let's say federal law says you're allowed to have 10 pounds of cannabis. Automatically, we're allowed to have 10 pounds of cannabis. Whatever federal law allows, we're automatically going to allow.
And let's remind everybody that 10 pounds is the ballpark that Washington has put out in their last idea. So yep. That's relevant. That's important.
Yep. It continues to give the OBN authority to enforce the rules, just like they have now. I think they've been very responsible in that. I've been very thrilled to basically get the sense that they haven't been, jackbooted thugs like I think of the DEA as. So they'll continue to have authority over enforcement.
And a shout out to Mark Woodward. You got to do that too. A shout out to Mark Woodward at the OBNDD for always being willing to come on and talk to us. So thank you. Go ahead.
This is just a little bit of a fiddly thing. Like if the federal government allows for something that's open-ended and doesn't specify what it is, our legislature can come in and specify it. But in whatever way they specify it, it must be at least as good as what we have here. So just a little bit of attorney input to just kind of cover a possible scenario. And here's one that I really like. Should either federal action be taken to allow for the interstate transfer of marijuana, or the United States Department of Justice issues an opinion or memorandum allowing or tolerating the interstate transfer of marijuana. Transfer of marijuana between this state and other states shall be permitted. Such transfers must be in compliance with the laws and regulations of both origin and destination states. So we had the Cole memo, right, under Obama, that basically said that federal government will be totally hands off when it comes to cannabis activities in a state. Imagine we have a new Cole memo, and the new Cole memo says, you know what? The federal government will be totally hands off between states that have legalized marijuana. So if Washington State and Oregon have legalized marijuana and want to trade with one another, we'll let them. If the federal government says that as just a matter of Department of Justice memorandum, like the Cole memo, then what that means is that our cannabis businesses will be able to take that as an opportunity for themselves. So either federal law changes, or we have sort of a interstate commerce level Cole memo.
You really think they would do something like that?
If we make them, if we make them.
Okay, well, that's a nice thought. But look, back up for just a second here. Let's go back to the taxes. So what you said is that at 3%, you've told us where 3% goes, and aside from that, you said the rest of it goes as it does in 788 through the general fund to education and things like that, right?
It also leaves it open so that if any other monies get earmarked in any other way, that's where they could go. Like the medical petition earmarks some monies for a few other things. And so those earmarks, if they become law, then whatever money comes from full access will go into the same pool and get distributed in the same way. If, for instance, we have an earmark from the medical of 1.5% going to research, then 1.5% of the taxes from the full access will also go to research, right? So in addition to any other expenditures of marijuana licensing and sales revenue authorized in law.
Okay, so then we need to get a hard look at those, where the money's going in the medical petition then. That kind of ties them together awful tight.
They're really, first of all, they're really small amounts, because when you see 3%, that doesn't mean the 3 of the 15, right?
Oh, I know.
That doesn't mean
right. I understand it's 3% of total sales. I get that.
Right.
The bigger number.
Right.
I think we should be doing more with it than just that. But
I agree, right? And so some of the things that I would be interested in would be, say, monies for job training and for housing for people that have been adversely affected by the war on drugs. Right. Somebody, for instance, who spent years in jail because of simple possession or a kind of ordinary cultivation charge, and it destroyed their lives. Maybe we should use some of this money to help them out. People become millionaires by going into cannabis businesses, while other people had their lives destroyed and spent decades in jail because of cannabis. And that imbalance is very upsetting.
Right. And I want to point out that it's gotten worse over the last year. And I think the moratorium on evictions comes up soon. I bring this up to say that one of our biggest problems to society is affordable housing or lack of affordable housing. So I believe that this needs to be helping in some way on the front side with some affordable housing, some way. I don't know how. Maybe you guys have some ideas. But
and let me say this.
Strong about that.
That when it comes to public housing, the federal law is that it's actually up to each jurisdiction to decide whether or not to allow cannabis users into public housing. It's up to each jurisdiction. And our state law says, unless federal law absolutely prohibits it, it must be allowed. And so the housing authorities throughout the state of Oklahoma that are denying people they're denying people their vouchers for housing, denying people housing benefits for being a medical marijuana patient are in violation of state law. And this has been a passion of mine. This is part of the reason why we created the OCLA, to try to fix this. And I've been trying to get attorneys, and I have some attorneys lined up, and now trying to get plaintiffs to say, yes, the Tulsa Housing Authority denied me housing because I'm a medical marijuana patient. That denial is contrary to state law, and we need a lawsuit to fix that. This could fix it. We don't know if this will ever pass, but we need to fix this housing issue.
Okay. On a lighter note, a friend sent me a screenshot. I had ORCA. I had a G instead of a C. So in the title, it's fixed. It's the ORCA organization, not ORGA. Little typo. But, you know, we've got people there ready to correct us. So thank you.
So Pamela, where can I find that I need to take it to do you mean the housing issue? Contact me through Messenger if that's what you're talking about. I can give you the resources for that. I look kind of weird, don't I?
What?
Most of my body's disappeared.
Yeah, you've taken on a bit of a weird look tonight, but that's okay. We'll be okay. All right. Well, we've just crossed an hour, so I think we're going to wrap it up. That's a quick look at the petition. There, you know, we can argue about it all night. I've got a few issues with it, as you've seen. I hope you guys have some more ideas. That's what this is all about. This community input period that ORCA has put it out for is for everybody to give their opinions. So I sure hope everybody does. I think it needs some tweaking. So Lawrence, any last words before we wrap it up?
Just to emphasize this, that our goal tonight is to help the pathway to public comment. And so there's a couple weeks, I believe, left as the public comment period. The website is there to receive public comment. So my hope is that by going over this language tonight, we've given people some of the resources they need to think it through and to offer their own ideas and input. You can access both the medical and the full access petition on ORCA. And
in a conversation I had with Jed, I think he said something about he'd be updating it probably once a week. So, I mean, we could talk about it at least once a week, or we could, since I'm thinking we might be doing a couple of shows a week, we might talk about the full access 1 week and then take another look at the medical a few days later. So, and so we look at both of them each week, as well as any other exciting topics. All right. Well, is that it?
I think so. Yeah.
Okay. Well, we will be back on Sunday night, right?
Yes.
And Sunday, Chip Paul's going to join us, so that should be an interesting one. I'll have to go back and watch our last show with Chip. We got into some of the science of it, so I'm going to go back, take some notes, and we can jump back into some of that conversation. It needed a little further investigation. What do you think?
There's always a lot of science to discuss.
All right. Well, that's it for now. Until next time, stay grumpy. I'll see you on the road.